Thank you, everyone, for joining the webinar on the impact of the coronavirus crisis on the workplace. My name is Rohit Kumar, the current SABANY Pro Bono Clearinghouse Coordinator. Before we begin, please note that a recorded version of this webinar will be available on the SABANY website, sabany.org, and members are encouraged to post the link to the webinar or the SABANY website on their social media pages. Our panelists today are Ms. Jasmine Patel and Mr. Amit Kumar. Jasmine is a partner at Franklin, Gringer, and Cohen, and primarily focuses her practice on counseling, management, and human resources professionals on various labor and employment law issues. How are you today, Jasmine?
I'm good. How are you?
Doing well, thank you. Amit, who in addition to being an officer on the SABANY board, is also a managing attorney for the law offices of William Cafaro and focuses his practice on employment law, representing employees in a wide range of disputes, including discrimination action and wage issues. How are you doing today, Amit?
I'm doing well. How are you?
Doing well, thank you. Thank you to the both of you again for joining us today. I wanted to begin by asking the both of you to address or highlight some of the main provisions of the Coronavirus Aid, Relief, and Economic Security Act, or the CARES Act. Amit, I'll begin with you. What is the CARES Act, and what are some of the provisions that may directly apply to employees?
Well, the CARES Act was an act passed by Congress recently to help stem the tide of the economic impact of the coronavirus. There are two main provisions for employees. The first one deals with unemployment insurance. What it does is if you're unemployed due to the coronavirus, the federal government will give you $600 on top of whatever you're getting from your state government unemployment insurance. And it also increases who's eligible to be considered unemployed or to receive unemployment benefits. So it's been extended to not only traditional employees, but also gig workers and people that might have been furloughed due to the coronavirus. The second provision, which I think is getting a lot more press from the media, is direct payments to U.S. citizens in an amount up to $1,200 plus $500 per child for those making $75,000 or less, or couples making $150,000 or less.
Okay. Jasmine, if you can add to that, what are some of the provisions that may directly apply to the employers?
So the main provision that applies to employers is the Payroll Protection Program, or PPP loans. Those loans could be 100% forgiven if employers rehire any employees that they had terminated or furloughed due to the coronavirus, and also bring up wages for any of the employees that they may have reduced. So the loan is, I believe, for 2.5 times the amount of payroll, and it has to be used 75% for payroll costs. And employees need to be rehired and brought back up to their normal wages. And if they do that, employers get 100% forgiveness. So it essentially becomes a grant. I did hear today that they have said that they're out of funds for now. It was on a first come, first served basis. And the $300-something billion has been used up. We're hoping that they'll add more money to it, or they'll come up with another package.
Okay. And did you mention what the terms of the loans were?
Yes. Oh, I didn't. So the loan is for 2 years at 1% interest, and payments will be deferred for 6 months if it's not 100% forgiven.
Okay. Thank you. Amit, if a family member or I get sick with the coronavirus, am I allowed to take time off work?
Generally, you're covered by the Family and Medical Leave Act, which allows employees up to 12 weeks unpaid leave if they've worked for an employer for a certain amount of time. The FFCRA, the Families First Coronavirus Response Act, allows employees who work for employers of less than 500 employees to take up to 80 hours of emergency sick leave. So you could use that time if you or a family member gets sick, to take care of yourself or that loved one. There are some specific caveats to the FFCRA leave. Mostly they're used for people who are subject to a quarantine order. They've been advised by a healthcare professional that they should be quarantined. They're experiencing symptoms of the coronavirus and are trying to seek a medical diagnosis to confirm, or they're caring for a child if their school has been closed.
Okay. And does the state provide or afford any protections for the employees, or one of those programs was a state program?
So those were all federal programs. The New York State does have greater protections for employees. I recommend anyone that might have any questions about that contact an employment attorney regarding sick leave, or if they have coronavirus or a loved one has coronavirus.
Okay. And in that regard, is my employer required to pay me for my time off from work?
Still me or Jasmine?
No, Amit, go ahead.
Okay. So as I said, for the FFCRA does require employers of less than 500 employees to give up to 80 hours of emergency leave. That's 2 weeks of paid sick leave under the FFCRA for those experiencing those symptoms I talked about earlier.
Anything to add to that, Jasmine?
Yes. So if someone's home to care for a child, then they do get the 80 weeks, but that's at 2/3 pay, I believe. And it can continue for an additional 10 weeks under the FMLA. And then the state has a law where employers have to give, depending on their size, 5 to 14 days of paid time off, but that's only in the case of if the employee has some sort of order from the health board or the governor or some other body stating that they need to isolate or quarantine.
Okay. And Jasmine, in the current climate, how are you counseling management and human resources professionals? Are there steps that companies need to be taking to prepare for changes in the current COVID crisis? Well, that some experts indicate may persist or continue for the next year or so?
Yes. So initially we received a lot of questions about, how do we reduce people's pay? How do we furlough? How do we choose between furloughing and laying off? And a lot of it has to do with proper notification to the employees. So absent an employment agreement, if somebody's at will, their pay can be reduced as long as they're still making the minimum wage or the minimum salary requirements. And employees can also be furloughed or laid off, depending on the circumstances, but sometimes advance notice is necessary. So it's determining what needs to be done and then in enough time to give the notice so that they can go then do the layoffs or the terminations or the furloughs. And now there's a lot of questions about, okay, this has been, a month. We held out as long as we could. Can we now lay off? And it's the same thing. Let's give advance notice. You can go ahead and do it depending on the circumstances.
And are you advising HR, human resources and management, in regards to addressing how they should respond to employees and their concerns about coronavirus as they return to the workplace?
Yeah, so we actually haven't gotten those questions yet. We have gotten questions from essential employers, who have employees who are scared to work. And so we're making sure that they're following CDC and OSHA guidelines and disinfecting, providing protective gear where necessary. And we're trying to make sure that they distance even if they are in the workplace, that they're still maintaining that 6 feet of distance within the workplace. Now employers, I just had a question today, somebody was asking, can we do tests before employees come back to work? So can we take their temperature? Can we do respiratory tests? And so we've been advising on how to do, what to do going forward.
Okay, thank you. Amit, can my employer fire me if I get the coronavirus?
Generally, the Family and Medical Leave Act, generally the Americans with Disabilities Act protects employees who have coronavirus and who have an underlying health condition that might be exacerbated by the coronavirus. You also have New York State law and New York City law, which actually may provide greater protections. If you feel that you've been terminated because you have got a coronavirus because you got the coronavirus, it's always best for you to contact an attorney to figure out what your rights are. It's a very fact sensitive, it's very fact sensitive. So you really do have to talk to someone who knows about the law to figure out whether or not any of your rights have been infringed on.
And could you briefly go over what the WARN Act is?
Sure. The WARN Act is a law created by Congress, and a federal law, as well as there's a mini WARN Act for New York state law, which applies to employees, which applies to mass layoffs. If your employer does a mass layoff, or what's considered a mass layoff under the law, they're required to give a certain amount of notice, and if they fail to give you that notice, there might be the action could be actionable, as in there could be a lawsuit, and you might have rights that have been infringed on.
Okay. In which cases you recommend that the client contact attorneys if that does happen?
I do.
Jasmine, do I have the right to work from home if I'm uncomfortable reporting to my job, even if I'm not sick?
If you are a non-essential worker, then the government is trying to have most people that can work remotely. But if you have a job that can't be done remotely, the employer does not have to give you that accommodation. But at the same time, if you're essential, the employer can have you work from the workplace if that's the only way that you can do the job. Okay. It's also a fact-specific inquiry about what kind of job you have and whether it's one that can be done remotely or not.
Sure, thank you. Amit, anything to add to that?
Well, not only does the employee have to be essential, the business has to be essential as well. So that's why it's very fact sensitive. And I would definitely recommend contacting an attorney if you feel that you should be able to work from home.
And Amit, if my employer does require me to work from home, am I entitled to be paid for that time, including overtime?
Yes, you very much are. It doesn't matter whether you're working from home or someplace else. As long as you're working for the employer, you're working hourly, you're entitled to the hours that you've worked. If you've worked over 40 hours a week, you're generally entitled to overtime. You're generally entitled to overtime. And if you're a salaried employee, if you're working from home, you're generally entitled to your wages then as well.
Thank you. Jasmine, advising human resources and management, what happens if my employer asks me to sign a severance agreement? Should I sign it? Should I not sign it? What would you say to someone who's asking you that?
Okay, so usually when you're given a severance agreement, there's some sort of waiver of claims attached to that severance agreement. So you're getting X amount of money in exchange for waiving your rights to file a claim under, city, state, local, federal laws. So my advice to an employee who gets a severance agreement would be to review it with an attorney, understand what rights you are waiving, ensure that the employer is giving you the right amount of time. Severance is not something that's guaranteed in most cases unless there's some sort of contract that says differently. So the employer does, if you don't sign it, the employer can not pay the severance, but you should definitely have it reviewed and understand what rights you're giving up.
Okay. And can an employer withdraw an offer letter or employment agreement because of changed circumstances like the COVID-19?
Yes, so they can withdraw an offer letter if now they can't, hire the employee because of what's going on. In terms of an employment agreement, it depends on what is written in the employment agreement. So the contract still stands. If there's a force majeure clause or something to that effect or a termination clause, they may be able to terminate it, but they may have to give a certain amount of notice. Anything
to add to that, Amit?
No, I would also recommend, like Jasmine did, I feel like a broken record at this point, but if you have a severance agreement and you have questions, it's always best to contact an attorney about the contract. And regarding the offer letter, if you've got an offer letter or an employment agreement and you feel that the employer hasn't lived up to the terms of the agreement, it's always best to talk to an attorney to see what your rights are.
Okay. And Amit, what if my employer or coworkers are discriminating against me? Any advice in regards to that?
Yeah, well, since the beginning of this this pandemic, we fielded a lot of questions concerning harassment in the workplace and discrimination based on race, ethnicity, and national origin. The type of mistreatment is discrimination and is very illegal under, not just illegal, very illegal under federal New York State and New York City law. I do want to be very specific. Discrimination has a lot of different definitions. It can go, and it can be anything from derogatory comments, racial slurs, stereotyping, and adverse employment actions, which would include poor performance, demotions, and termination. If you feel you were discriminated against or subject to a hostile work environment because of your nationality or race, or national origin, it's really important for you to contact as an attorney who understands the law and can really go over the facts and figure out whether or not what's going on is actionable.
And Jasmine, from the employer standpoint, has anything changed in terms of how they should respond to discrimination in the current climate?
No, so the law still stands. So if they get a claim, they should address it, with an attorney immediately. We have been advising our clients that if they're contemplating terminating people or laying off or furloughing, that the method that they should, in choosing the employee to be furloughed or laid off should be something that's neutral. So not discriminatory, meaning how, reverse seniority. So if they've been with the company shortest, maybe you lay off those people first. Or if you need one division and not the other division, you can lay off the division that you don't need, but choosing a neutral way to lay off or furlough rather than basing it on something that could be arbitrary or considered discrimination or discriminatory.
Thank you. And I guess this question is to the both of you. In the current climate where everything is changing so rapidly, what would you advise your clients as to some of the resources that they can kind of turn to? Amit, I'll start off with you.
There are plenty of resources for people who feel they've been discriminated against or are unsure of what their rights are. Your best bet is to contact an employment attorney who will know whether or not any of your rights have been infringed upon. Other than that, there's always just Googling the various laws that we've spoken about today, which would include the Family Medical Leave Act, the FFCRA, the WARN Act, the New York State Human Rights Law, and the New York City Human Rights Law. Now, they have a complex web of protections for employees using all of the laws that I just specified, and a few others. So that's why I'm saying it's always best to contact an attorney that knows about employment law to see whether or not your specific situation gets caught in that web, and someone will be able to help you.
Anything to add to that, Jasmine?
I'll echo what Amit's saying. It's always best to speak to an attorney. If you're an employer and you're trying to obtain a PPP loan, you should go to a certified lender, which is, your bank that you usually bank with should be able to help you, or your accountant. If it's something about the loan, it's good to go to someone who's a certified lender or the SBA directly. Even though they're not the ones accepting the loans. And then if it has to do with an employee issue, contact an attorney, and they should be able to help you.
Well, thank you. No, that was great. I think that's some very important information that you guys sent out there today. Again, before we do sign off, please note that a recorded version of this webinar will be available on the SABANY website, sabany.org. And members are encouraged to post a link to the webinar or the SABANY website on their social media pages. Thank you to the both of you. Again, thank you for taking the time to be with us today and providing all that important information.
You're welcome.
You're welcome. Thanks for having me.